unfortunate world where women have to work twice as hard as uh, twice as hard to reach half as far as their male counterparts. Wading through these streams of ups and downs, our upcoming speaker has shattered the glass ceilings and has made a place for herself in the world of law. Today we have Ms. Kenny Thakkar, who is the founder of KBT Legal, Mumbai. She is a versatile advocate and consultant with an experience of over 8 years in handling cases like divorce, domestic violence, partition of property, summary suit, money recovery suits, cooperative society related issues, uh, and being retainer for corporate bodies, drafting various documents like will, MOUs, deeds, etc. And she's a experienced professional on our today's topic, that is debt recovery. When we think of debt recovery, we know how painful sometimes the whole process of getting your money back, and sometimes you also not aware of the legal proceedings or what forums you should to reach out to get your money back. And you may face a lot of questions while itself, which forum you should approach and which tool you should use. So today's discussion or topic discussion will be wholly one based of this, not from a very strict point of view, strict legal person. So our today's webinar is intended for a common man to understand the nitty-gritties of how to approach different forum in the matter of debt recovery. And one more topic, important aspect, which we are going to cover today is who can lend money and is it legal? Like sometimes we lend money on ways to friends or someone, sometimes with document, without document. So what are the things we should understand when it comes to lending money, and where we intend to charge a certain percent of interest on that? So is it legal? So I would like to welcome our speaker and to throw some light on this topic. Welcome, ma'am. Over to you, ma'am. Ma'am, I think you need to unmute yourself, ma'am.
Thank you, Ajay. Thank you very much for giving such a wonderful introduction for me. Thanks a lot. Firstly, I would like to talk about debt per se. I mean, what debt in general means. In simple words, debt means any liability, means anything that you have to claim, take, or ask for from any organization, be it your company, be it a company or a financial institution, or any activity which is arising out of business transaction. Basically, you did business and you have to take money, or you that's ideally. Now the next question that comes into mind is what kind of business. So to that I would like to say that business basically means a activity which is legally valid in law. So for example, I say that okay, I'll pay you 50,000 rupees. You do an activity like, say, stealing some goods, or something of that sort. That's not a legally right business activity. That's not legally permissible business activity. So you cannot claim that amount as debt, even if the other party does that kind of a work, and if you want to go and recover, no. So in simple words, in simple, very, because today's presentation, I mean, I personally feel it's going to be from a perspective from a law students, or people who are not from legal background, business owners, or someone who will actually relate that what the debt is. And I want to give a bird's eye view on what the entire process is all about, how it goes about, and what things you have to keep in mind to ensure that you are legally correct. So it's just an awareness that I'm trying to spread through this presentation. So this is what is a debt, the meaning of debt in very simple words. Then the question is when it's debt recoverable. So now this is a very interesting aspect. So like today I lend a money, and then can I recover the money tomorrow itself? So when is it recoverable? So first thing is it has to be a transaction, a business transaction which is valid in law. First thing is that the debt that you are claiming for has to be arising from a transaction which is very, very legally valid in law. Second thing is it should not be barred by time. Now there is a act called Limitation Act. So if you want to recover your debt, then it has to be a time frame within which there are laws which clearly say that what debt is cleared, recoverable by what time. So the transaction has to be falling within that period of time. The debt has to be falling within that parameters. Then you can claim. So like suppose today I give a money, I sleep for it for 10 good years, 12 good years, and then one fine day I wake up and say that "Arey, I have to recover the money from you, give me." You cannot recover it in that way. It has to be legally falling within the limitation. Then who is a debt is recoverable from whom? It can be individual, it can be a firm, it can be companies, it can be financial institutions, or it can be any natural or juridic person. But it cannot be a minor. So suppose I give money, so say 16-year-old or a 14-year-old, and I say that no, I paid you, we executed a contract, we did everything, so now you paid back. No, it cannot be with a minor. So the idea of sharing this is to get an ad, to create to share a knowledge on the point that these are the people with whom you can and cannot do any kind of transaction. So while lending your money, so for example in a business transaction, it many times happens that okay, my friend wants money, he told me that you transfer the money in account of his minor son. I transferred it and now my friend is not paying. So now legally you cannot, because he's a minor. I mean, and he's and your very transaction is not void in law. So then the idea of sharing this point is to create a caution that okay, these are the points that I have to consider while lending it. Now chalo, debt is given, now the debt has arisen, you gave the money. Now how do I recover? So I'll try to give you an idea that debt can be recoverable in many ways. So there are some remedies which are of civil nature, some remedies which are of criminal or punitive or punitive, as you say, nature. So ideally, at times you can take a combination or you can take one remedy. So what is civil remedy? Civil remedy basically means a remedy by which you are actually going to the court, asking the court to direct the debtee to pay you the money, to recover your debt. So that's one process that you do for recovery of money. So now what kind of suit I should file or what it happens? So basically you can file money suit, commercial suit, or a summary suit. Now basically I'll not go very technical, but suit means a kind of a suit is a claim that you're putting up before the court of law. So for money, you are saying that I did so and so business transaction, this is the debt arisen, he has not repaid it, kindly pay him, ask him to pay. So that's money suit that you're putting it. If it's a commercial, there is a Commercial Courts Act which has come up, so which provides a specific provision for commercial suit. So you're taking up you're filing a commercial suit there, or a summary suit that you're filing like when the other party accepts the claim. And many a times it so happens that in a business transaction the other party says okay, give me 15 days time, I'll repay, or the debt is very much acceptable in black and white. In such kind of case, we put up a suit saying the court that see, now the debt is admitted, so a decree may be drawn on the basis of the admission they made. In such case, the defendant, that is the person who owes money, who owes to repay the money, has to really justify and give a bona fide reason before the court as to why is he entitled to defend. He has to take permission to defend the case. So these are the three kinds of remedies that we put up before the court in a civil, normally in a civil perspective. Now, what are the points to be considered while you are dealing with a particular suit, whether the debt is operative or is it by time barred? So like normally there is a period of 3 years. Obviously it varies on case to case and circumstances to circumstances, but ideally 3 years is a period for which you can recover your debt. So are you falling within that 3 years? Is the last payment made within 3 years, or is the part payment made within the period of 3 years, or is the debt admitted within the period of 3 years? So that is one parameter which is normally looked up to fit in that, okay, my claim is not time barred. Second thing, so that's the point. As an individual, you have to assure that, okay, it's not too long, my debt is not too long, so that let me take up the legal recourse if at all you wish to. Second thing is whether it's a legal transaction or an illegal, which I already discussed, whether it's a valid transaction, whether the other side has disputed or undisputed, whether the debt is disputed. Like, for example, many times the defendant do say that, no, this is not the claim that I have to pay. I have never received any kind of money. There's nothing. So if it's a disputed one, or is it a undisputed one? So those things are to be taken care of. And what are the evidences that you have in hand, or circumstantial or electronic? So this is a very, very interesting and a vast topic in itself. Evidence means what are the documents on the basis, or what are the evidences on the basis you are claiming that this is a debt that I owe. So basically, in court of law, the burden of proof is always on the plaintiff, that is the person who is making the claim. So if I say this is a debt that I want to recover, then I have to come with documentary evidences or electronic evidences or circumstantial evidences which explicitly make out my case that yes, this is the amount I owe pursuant to this transaction. So for example, business transaction. So then you may have your bills, you may have your challans, you may have mails exchange, which is again an electronic evidences. You have everything, and there is no dispute. Basically, the other side has, if there is a contract, of course, contract. So basically, it clarifies, okay, this was a transaction, this is the money paid, and this is not the money which was ideally to be paid within this stipulated period. It is flouted willfully, and hence the claim arose. As simple as that. And interest. Now, to claim interest, ideally, in summary suits, in other suits you can claim, but in some forums it is, you can claim interest only if it is mentioned is either in your bills or in your contract. It is explicitly agreed that what will be the rate of interest and what will be the interest, how will it will be charged. So those are the points which are to be taken care of. So like, how is it going to be useful for you? So if you are a businessman, or if you are a person who is lending money, you have to ensure that you have all these things in place. Is your interest clause in place? Is your documentary evidences and all kinds of communication in place? Whether the debt is within the parameters of time frame stipulated. All those parameters have to be considered before proceeding in a court of law. Then after that, this is one side of it. This is about civil normal process for recovery of money and all. The other part, the other angle comes is penal provisions. Penal provisions means it's obviously an offense, or it's a method to put a kind of pressure on the person from whom we owe a debt. So this is an punitive or arm twisting technique, which is normally adopted with an intention to put a kind of pressure on the other side. So now it can be 138. Now many of you will be astonished. 138 is it a pressure technique? Yes. Ideally, the act focuses on giving punishment. It does not focuses on recovery. The amount that you get from the court is in form of compensation. It's not the debt that you are. So it's a compensation that you are getting. So 130, that's normally called as check bouncing cases. So that is one thing. Then filing of criminal complaint. If the kind of fraud is really big, and there are a lot of number of members, people involved, so they can go and make a complaint before either the concerned police station, or alternatively they can go before if police is not taking the cognizance of the matter, they can definitely make a private complaint before the magistrate court and take appropriate recourse for registering an FIR and taking the case forward. So again, the idea is to punish the offender. The idea is not to recover the money. So that is one thing. And the other thing, this will be applicable only in case of companies. If the debtor is a company, okay, so in that case, one can initiate insolvency proceedings against that particular company, whereby the pleadings made is that this particular company owes so and so amount of debt. Since they are not competent to pay their debts, they are, or they have flouted, and a resolution professional be appointed, who will look after the day-to-day transactions of the company, let the company go in liquidization, and then accordingly the debts may be paid to the creditors and debtors. So now it depends whether the idea is you may fall under a secured creditor or a debtor, and what is the amount of assets the company has. All those things are to be are taken into consideration by the professional, and then he reimburses the money. But you may, one may get or one may not get, but ideally it is seen that in most of the times, most of the cases, if the company is doing well with their businesses, the possibility of settlement is really high, because no company wants the company to be no director or ideally wants, if they are functioning well in their business, that the company goes for liquidization. So these are all arm twisting techniques adopted for putting a kind of pressure for either settlement or for recovery of debts. But the ideal way is that. Now, again, when you want to initiate criminal or such kind of punitive recourse, what are the points that you have to consider? So, in case if you want to initiate 138 proceedings, so then in that case, you have to send a notice within 30 days after the bank intimates you that the check is dishonored. So this is one major parameter. So if the check is dishonored within 30 days, a statutory notice has to be addressed. So if you are a businessman, you have to make it a point, okay, this is a check, so let me consult my lawyer and take it forward. This is like within 30 days. Again, as I said, interest clause, ingredients of invoice, is your invoice in place? Is every my invoices in place, and all of those aspects. Then what is the mode of services? I mean, supposingly I do see many a times people say we delivered the we delivered the goods, but now they are not repaying our money. But where is the proof of delivery? What is the date of delivery? Where is the proof of delivery? All those factors are to be considered, be it civil or be it criminal. All of those aspects, those small little things make a hell lot of difference in your presentation before the court. Whether the debt is admitted or has it have you received a part payment? So all those pointers make your case a little simpler. Then comes the other part, simultaneous proceedings. Now, many of you may feel that, okay, should I go for civil or should I go for a criminal thing, or should I go for a combination? So, for example, I'll make it very simple. So, what is the limitation of 138 proceedings and all? See, if I owe a debt of say 50 lakhs or a 60 lakhs amount, 60 lakhs of rupees. So, in that case, the amount, and I have a check which is dishonored for say amount of 25 lakhs or 30 lakhs. So if I initiate 138 proceedings, then the amount for recovery will be only the amount which is mentioned in the check. I cannot claim the whole amount, although that is a pending amount, although that is also a debt falling within the purview of definition of debt, but I can claim only the amount which is mentioned in the check. So like, what should I do? So if you want to, you can go for both the options. You can resort for a recovery proceedings as well as a criminal proceedings, or you can choose, okay, I want to recover, but the moment you take up 138 proceedings, you have to stick to that, to the amount mentioned in the check. So ideally, it is normally suggested that if one can adopt one or more proceedings depending upon the facts and circumstances against the defaulters. And in case of civil or money, money, as I said, civil, in case of civil case, money or compensation, and in case of criminal proceedings, the idea is to penalize the debtor. So you have to ideally go for combination, simultaneous proceedings. So far, I think I wanted to keep it very, very brief and crisp so that we can have some time to take question answers. So these are the main aspects which I wanted to focus on a particular topic. Then comes money lending thing. Now the idea of money lending, money lending facet is very simple. So money lending basically, I'll tell you a case study. Recently, a person one of my client, he had lended a money of more than 1 crore. He gave it through check. He executed probably a document to that effect, and he mentioned about the schedule of the payment. He mentioned about the interest clauses, what will be the interest chargeable, all of those factors. But yet when the other side defaulted in making payments, he could not take it legally. Do you know the reason why? Because he did not have the license to lend money. See, the objective of money lending act is the government always wants that lending should be practically done through financial organizations or in an organized sectored manner. So if an individual starts giving money to each other on interest basis, it will affect the economy, or there will be the possibility of misuse of this particular act. So there is a money lending. So most of the times many individuals do not know about this act per se. So yes, I would like to just highlight on that point here is that when you are lending a money, and if you are trying to then ensure that do you have a money lending license. So if all those parameters are fitting well, then you can. If you have a license, you can. But without a license, giving money and then leaving on a presumption that we are executing a contract or an agreement to this effect, then I'm super secured. Legally, I'm correct. No, you're factually you may be right, but legally you may not be correct here. So these are the points which I wanted to focus. These are the main pointers that I wanted to give a very brief idea about.
Ma'am, we have few questions in chat box actually.
Yes.
The first question is, can 130 proceedings and civil case run together? Questions from
Yes.
Abhijit Sharma.
Yes, it can definitely run together because, as I explained, that is a civil remedy, that's a punitive remedy. So you can definitely take two parallel recourse.
Okay, ma'am. Thank you. The second question from Jay. What is the debt recovery process for MSME?
So, Jay, the act explicitly sets out the process of MSME. You have to register your complaint. See, the process of recovery before any forum is going to be in the method that is stipulated in the act. So, MSME will talk about you. You will have to put up your claim. They have an arbitrator or a mediator who will look up the case, and then he will hear you out. So the moment you go for an MSME option, the other options are not are closed for you. That is one option, and the process is going to be more or less the way in which the process may change in the sense that you will have to make an online complaint and all of that. But the points which are the idea of this presentation is to create an awareness what points are to be taken for which process, what points are to be taken into consideration before going to a court of law. So this is for that perspective.
Okay, ma'am. So next question from Vinay Sharma. Vinay is, if we lend money to friends or family, then too it is required to have money lending license.
Yes, basically it's an interesting question. So when I would like to say that of course you can lend money to your friends and families, but you cannot claim interest over it. Then it has to be a very, very much a friendly loan, as we say, which is interest-free loan, which is given on a friendly basis. If that is the case, you can get it recovered from the court. But if you have given a loan which with an intention of fetching an interest, then definitely you need to have a money lending license.
Okay, ma'am. Thank you so much, ma'am. Next question from Anubhav Garg is, what is the difference between money recovery and debt recovery, or debt or money lending, if any?
I ideally, I do not find it a major difference. See, debt or a money. See, basically, debt. I explained the definition of debt. I mean, there are multiple definitions of debt in various acts. So, if you in generic see debt, so it's an amount which is to be claimed, or it's an amount which has to be recovered from a business transaction falling within a stipulated time period. So it is that. So, but ideally, when you file a suit, the terminology used is money suit or suit for recovery of money, because that is about the prayer. So debt is a liability which is arisen out of a transaction, and the amount to be recovered is in form of probably it's a money. So basically, there is no major difference per se.
Okay, ma'am. Thank you. Next question is, can you list out different forums for debt recovery apart from the ones you mentioned, like MSME, NCLT, SURFACE, and such other? Maybe he is trying to understand which forum you can go for a particular suit.
So basically, I would like to say that, see, NCLT is there, SURFACE forum is there, MSME forums are there. So it depends upon, see, it's a very vast aspect altogether. So it depends upon on which DRT, you can say DRT is a forum. So basically, you cannot generalize the forums. It is about who are the individuals who are transacting, what is the nature of transaction, under which act the transaction has arisen. All of those aspects are to be considered, and then you can decide on a forum. You can't have a checklist of those things. That's what I believe. I may be wrong. This is my presumption, with due respect, but this is what I would like to answer.
Okay,
you have to understand the whole transaction per se, and what are the parameters. Basically, these are the very basic parameters which I discussed today.
Yes, ma'am. Next question is, lending money by individual by way of agreement, is it legal or illegal?
Lending money again to an individual
like between two individuals through an agreement,
you
is
can
it legal
execute
or
a promissory note. You can execute a promissory note and lend money. That is definitely okay. But the point over here is that if the idea of lending money is to fetch interest, then that's not right legally without a money lending.
So pure principal recovery is absolutely fine. It is legal.
Yeah.
Okay. Next one is, in case of non-payment of money, should we file a case for cheating as well?
Yes, as I explained in the in my presentation, that you can take simultaneous proceedings. So when you make a complaint before police or before a magistrate, in case the cognizance of the complaint is not taken by the police, ideally 420 does fall. But you have to ensure that ingredients of cheating are falling into it. Cheating is defined under Indian Penal Code, and when you are trying to make out your case, you have to ensure that the ingredients of cheating are falling into the transaction. Only then you can proceed. But yes, it's an option.
Okay, ma'am. Thank you, ma'am. Next one, how to procure money lending license? How much time does it take? I'm not sure this is what.
Anubhav, you can contact me in person for that.
Yeah, maybe we'll share ma'am's contact details before we end the webinar.
Yes, Anubhav can contact me.
Yeah. Next one, if I give money to my friend and he don't repay, and it's been more than 3 years now, can we recover the money even after the time frame of 3 years is passed?
Yes, this is a very subjective question, but yes, I would like to say that if you have lended the money, do you have the proof of lending? I mean, in what form did you lended the money? Through what was the mode through which you made payments? So was that the transaction? And if 3 years has passed, ideally it will not. But still, I would not say that the option, because it depends upon the communication that you guys exchanged and the documents, if at all existing. All of those parameters are to be considered. If there is a possibility, you can, but otherwise in general 3 years means debt is time barred. But definitely it has to be considered as a case to case. You can't have it as a thumb rule.
Okay, ma'am, should I let participants speak, like, if they want to ask in between follow-up questions? Because right now, is it okay then? If that is okay, then I'll allow participants to speak.
Fine.
Sorry, everyone. Our speaker has lost her internet connectivity, and she's trying to join.
Yeah, I'm here.
Yeah, she's back.
I'm so sorry for the inconvenience.
Ma'am, one question is, can I ask you the next question? Are you able to hear me? Ma'am, can you hear me?
I can.
Yeah. One question is, stocks brought from a registered firm to another registered firm, and for those stocks, a check was received, not from the firm, but from a person who is working in received firm. The check was bounced. Can we proceed legally? And the check was bounced over a year ago.
Basically, what I understand is stock was transferred from one firm to another firm. Now,
yes,
again, right? That actually my internet dropped, so I am not able to read the question here. So I'm trying to clarify. Yeah, I have lost that question. So basically, stock was transferred from one firm to another firm, right? So in that case, first thing is like whether there was a contract to that effect that the stock will be transferred from one firm to another firm. That's one thing that has to be considered. I'm just trying to break down, Second thing is, yes, the check was given, whether the check was dishonored. So the moment the check was dishonored, to take up a legal proceeding through 138 proceeding, the notice has to be sent within 30 days. So that period has lapsed. So he cannot take a legal recourse under that particular remedy, but he can go for a civil suit or another legal options that are discussed in the presentation.
Okay, and one more thing, it was saying that the check was not from the firm, a person working in the firm.
So then
does
again
that
the
affect?
clinch, yes. So again, again here the clinch is how will you prove the liability? So the moment you are claiming that this was the account through which the check was issued, so you will have to prove the business direction, business transaction. How will you post your, put up your business transaction the moment you say that this is the transaction of this type? So you will not be able to prove that. So again it will be a problem, because a person, now again here, see, I have to go through the documents. That is what I'm saying. It's not a forum where you can discuss your personal matters, but still I would try to say that, see, again here, now what was the capacity of a person who was issuing the check, whether he was a proprietor, whether he was a partner in the company. So what was the contract, what was the kind of communication transpiring between them? All those parameters have to be considered, and then you can initiate any legal proceedings. I have one question here from 𝗗𝗲𝗯𝘁 He says, one of my customer is not paying me. I have delivery challenge. I have not raised a bill. As amended, PO is not available. It is a construction project. I have also not raised bill due to GST liability. Now, what to do? So that's what 𝗗𝗲𝗯𝘁 is asking me. To this, I would like to say that you need to have a bill. Only then you can say that this is the liability. Now, never mind. Ideally, if you have a challan, on the basis of challan, it has to be very subjective. Because you have to prove that first. Your liability has to be proved first. Yes, sir.
Okay, can I ask this?
Yeah.
One person asking, even on a promissory note, interest cannot be levied without license.
On a promissory note, it can be, because the person is promising to pay. Here you are asking, so it can be, in my opinion.
Okay, thank you. Next one is, which matters or transaction go to debt recovery tribunal? Can you explain it in detail of matters before DRT?
No, I cannot hear at this point of time. I cannot, due to paucity of time. I cannot. But if the person wants, he can contact me in person.
Okay. There was one more question. The latest one. Person approached B to give 50,000 to take her wife to hospital. Both reside side by side. With good faith, B gave the said amount B by drawing from bank ATM on that late night. A promised to repay it in a couple of days. No witnesses. He failed to repay even after 3 years. What is the remedy to get back my money? So basically, he gave 50,000 rupees in good faith to someone, a friend or something, and he is not repaying the 50,000 rupees.
Again, the same question.
3 years,
He paid the
3
money.
years has elapsed.
Yeah. So again, the same thing. How did he pay? What was the mode? What is the mode to prove what he paid? All those factors. Now here he paid, but there is no proof to show that he made the payment. Now it depends whether the other side is admitting that yes, I received the money, then the case takes it to another angle altogether. If there are any communication to that effect or anything of that sort.
Okay, basically you need to have something, some documentation for that.
Yeah, some facts. If he has paid the money, he must have made some kind of communication. The other side must have admitted or said that thank you for the help. I will repay you in say X amount of days or anything of that sort. If those things are there in place, then in that case it's a different thing altogether. But if all those things are not in place, how will you at first place prove that I removed this money? You will prove that I removed this money from the ATM, but how will you prove that I gave it to him if he says, no, I haven't received? Again, yes, hospital bills of the wife, the amount, all of those factors have to be tallied. So it's something that you have to go in depth.
Okay. Next one was, Maybe if you can share your email ID or mobile number, people have follow-up questions, they can directly reach out to you. I understand we have taken a limited time from you. I have shared the speaker's contact number in chat. So I request Anubhav and few others who have Mr. Sandeep who have further questions regarding that to take it up with the speaker directly. She is ready to answer, but she's not able to join us back right now. So I thank all of you for joining this webinar. I hope this was informative to you all. So thank you on behalf of LawSikho. Thank you so much.